and their effects on families, because they are so critical to military families and oftentimes are some of the reasons that they become involved into the attention of the justice system. Next slide, please. The guide is laid out really nicely in a variety of sections. So if you want to flip to a specific case type, we have sections that address things you need to know about family violence cases, child abuse and neglect cases, juvenile justice cases, as well as domestic relations. And each of those sections not only presents information and content to you about military families under the context of those case types, but we also specifically address judicial considerations for those cases, questions that you may want to consider or asking in hearings for those cases, any relevant or pertinent governing laws and policies. And then we also list quite a few resources and direct links to those resources specific to those case types. Next slide. I do want to introduce, we have 3 expert faculty with us today. We have the Honorable Jason Fleming. He is a judge in the family court in Christian County, Kentucky. And that his court is near the Fort Campbell Army installation. So he has a special interest in this area. And he has been a long-serving member and even a past chair of the National Council's Military Committee. Colonel Mark Sullivan is a private attorney. He operates a family law office in Raleigh, North Carolina. He's a retired Army JAG colonel, and he is the author of the well-known Military Divorce Handbook. He's also a long-serving member of our military committee. We also have Stephanie Bowman, who's an attorney, a senior program attorney in our Family Violence and Domestic Relations Department. And she has been part of our Military Families in the Courts project since its inception in 2018. And now I'm going to turn it over to Stephanie, who has the very first section to talk about issues in family violence cases. Next slide, please.
Stephanie, you're on mute.
Thank you. I was trying to tell Fabiola I could not move the slides forward. So I'll need somebody to do that. And of course was on mute when I did it. So yeah, always around a great start for my presentation section. Thank you everybody for joining us. As Sherry said, my name is Stephanie Bowman and I am an attorney with the National Council. I have never been in the military, but I have done a lot of work with victim services, representing victims and working with law enforcement in communities next to installations. And so have been a part of that community coordination with military. So that's what I bring to this section. And before we talk about, I think it's important to recognize that in my section, I'll be talking about what Department of Defense policies and instructions say about what their duties are. And just like state courts and jurisdictions, all the statutes and rules and all that may be implemented differently in different jurisdictions. So just because this is what the DoD instruction says doesn't mean that that's exactly how it plays out in every installation, and why it's so important to make sure that you're making connections within the installation that you are working with in order to be able to have better communication and coordination. So if we can go ahead and move to the next slide. All right, so we can't really talk about the military's response to domestic violence without talking about the Family Advocacy Program. They are really the #1 resource in my experience for victims of domestic violence, as well as some other services that they do provide for families. They have a lot of different services, but they are the home of the domestic abuse victim advocates. And so they're the closest thing you're going to have to a community advocacy resource. They're going to be the people that walk through the system with victims, helping to connect them to services. They offer clinical assessment, victim advocacy, and other support services. They also provide domestic violence victims with information about reporting, restricted and unrestricted reporting, and we'll talk about that in just a second. They also walk through and coordinate investigations at the victim's request. So that's where they can also sometimes fill that victim witness coordinator role that we have in the civilian court system a lot of times. They're also responsible for taking steps to ensure language access for victims. And they're also in the DoD instruction 6400.06 told that they need to be assessing for risk for re-abuse at every contact they have with the victim. And that's similar to community advocates who are going to be doing safety planning every time they meet with a victim. So very similar in a lot of ways, but a lot of differences as well. Can we go to the next slide? So in order to be eligible for the full list of family advocacy program services, domestic violence victims need to be eligible to receive medical care from the DoD, and that includes those eligible on a fee-paying basis, and will so those that are available somehow to receive medical care from the DoD are going to be able to reach all of the different services that the Family Advocacy Program offers. Those that are not eligible are still able to do an initial intake where they get a risk assessment, safety planning, and referrals to appropriate civilian support services. So it's not that if you don't qualify for their full services that they just leave you with nothing. They do provide safety planning and important referrals to local programs. For the alleged abusers, so the other interesting thing about the Family Advocacy Program is they're also providing services to alleged abusers. And again, they're eligible if they are eligible to receive DoD care, medical care. They're then eligible to receive FAP clinical services, and that's where you'll find the abuser treatment. Oftentimes on military installations will be through the Family Advocacy Program. They have clinicians, so along with the domestic violence advocates, they also have clinicians that are able to provide counseling and services. Those that are not abusers who are not eligible to receive their full services will only be offered an intake assessment and referral to appropriate services. So I also wanted to take a moment to note that while in the civilian realm, we oftentimes in communities, especially when there's a limit of resources, kind of lump domestic violence and sexual assault together, including whether or not that sexual assault has an intimate partner relationship or component. In the military, the issue of sexual assault between enlisted members is a very big issue, and there's an entire different department, an entirely different confidential reporting, restricted reporting requirements. And so if you hear somebody talking about a sexual assault prevention and response team or sexual harassment assault response prevention, so SAPR or SHARP, they're talking about those services through the sexual assault side of care. And so I just wanted to make sure that we mention that. And there is a reference in the guide to how to find out more information about sexual assault. So when we start talking about reporting options, we need to remember that, so these reporting options that we're talking about are only available to adult victims of violence. If you're a minor, that would fall under child abuse and therefore would be a mandatory report. So we're only talking about adult victims. And restricted and confidential reporting, this kind of reminds me a lot, if you may be unfamiliar with the restricted and confidential reporting within the military, but have worked with universities around their reporting and confidential reporting, it's a bit similar. It depends on who you report to. So in the military, if you report to a DAVA or domestic abuse victim advocate, a family advocacy program clinician, and a healthcare provider, with the caveat of subject to state law, any of those individuals can take a restricted report. And again, it's available to all those that are eligible to receive medical care from the DoD. So what does it mean to have a restricted report? So sometimes victims are not at a place where they feel safe leaving a relationship, or they may feel that having someone investigate, or the fact that they reported being found out by the abuser could put them at an increased risk, the severe danger, that they feel like it's not safe for them, but they still would like to seek services. They'd still like to do safety planning, and they'd still like to have some counseling. They may want to do a restricted report. And that's because a restricted report means that law enforcement does not get involved, that command also is not involved. So there's not an investigation about the incidents, but the victim does have access to the full range of services from the family advocacy program. And another, and so again, similar to how reporting is implemented in a lot of university settings, restricted reporting options cannot be used if there's immediate risk of serious harm. So that's a little caveat in there. If the person who is reported to feels that there is immediate risk to the individual or to another person, they may decide that the report cannot be restricted. Next slide. And then for unrestricted, non-confidential reporting, the Family Advocacy Project will notify both law enforcement and the service members' military commands. And so what an unrestricted report means is that there will be an investigation of the incident, and the alleged abuser will be contacted about the allegations. Again, command will be notified. The victim also then has the ability to seek a military or civilian protection order. The victims have access to a full range of family advocacy program services, so similar to the restricted, but all these other services as well. They also have access to legal services on the military installation, and they can receive assistance in applying for transitional compensation. Transitional compensation is something that is very complicated, or can be very complicated, and is a little bit beyond the scope of this webinar. So we have provided some additional information about where to find more on transitional compensation in the guide. And another great place for resources is to look at the Military One source. They have a whole lot of information about the family advocacy program, their services, about military policies around family advocacy. And so just a great bit of resource there. All right, so what about if the victim tells somebody else? So again, as mentioned, there are different reasons that victims seek help, and there are also different ways victims seek help. And so the family advocacy program, a victim may not even know about the family advocacy program when they start seeking help. They may talk to a friend, a family member, a peer. And so the DoD recognizes that, and recognizes that family members and peers are support systems. And so it's not, so you can still file restricted or unrestricted, even if you have told somebody outside of those professions, but there are some caveats to that. If the victim informed their or their alleged abuser's chain of command or a Department of Defense law enforcement officer, there can be no restricted report. And if a chain of command finds out about the incident through independent channels, an investigation can be initiated, even if the victim filed a restricted report. And so that that can, if reporting to other people can lead to that issue of losing the ability to keep a report restricted and initiate that that investigation. So if you can move to the next slide. So there's a form, a DoD form 2967 that that lays out the domestic abuse victims reporting options, gives them all the information they need, and really lays out. Sorry, I'm getting lost in my notes. Lays out what those options are and has it in writing for the Department of Defense. So we have that form, and if you look on the bottom of the form, which is the next, or within the form, it also provides information for as far as exceptions to that restricted reporting. And so some of these are similar to in civilian areas and working with victim advocacy programs in a community. Authorized release in writing from the victim can mean that information shared with the victim can be shared. There's also if it's, again, those instances where there's a serious or imminent threat to either the victim or another person. There's also exceptions for working with supervisors. So the supervisor of the domestic abuse victim advocate or FAP clinician, they may talk about it with them. Just different exceptions that may be important for a victim to review in order to know how exactly their information will be used when they share, so that they can make informed decisions about continuing through the reporting process. Next slide. So we're going to move into talking about, that was a quick and short summary of reporting options, but we're going to move quickly into talking about military protective orders. And because of how military protective orders come about, they're ordered by command. It's important to talk about what command's duties are. And so according to DoD instruction 6400.06, commanders have the overriding responsibility for the response to domestic abuse. The installation commander is responsible for the family advocacy program, installation law enforcement and housing, and service member commanders have responsibilities for victim safety and for appropriate abuser accountability if the service member is the alleged abuser. So that's important to keep in mind. Unlike in civilian areas where we're going to have the courts making a lot of these decisions, in the military around protection orders, it's going to be really dependent on the commanders. So if we can move forward. So again, the DoD instruction gives the commanders, says the commanders will ensure protections of all persons alleged or known to be at risk by issuing and enforcing an appropriate military protection order. And that, so they are the ones responsible for issuing those and enforcing them. And commanders should make sure that they consult with the judge advocate in order to ensure that military protection orders are not less restrictive than those issued by civilian courts. So it's important to note that military protection orders are not something that it's an either or. A lot of times military protection orders can be used to give someone time to seek a civil protection order, but that they can offer similar but also very different protections or remedies, and that they're also going to be enforced differently a military protection order is not going to be able to be enforced by local law enforcement. But we'll talk a lot about that in a second. We also want to note, so it's important that the like MPOs cannot contradict civilian CPOs or civil protection orders. The terms cannot be less restrictive, they cannot contradict, they have to follow and be supportive of those. And then also commanders are to notify through installation law enforcement, civilian law enforcement authorities of any issued MPOs in accordance with their policies. And we'll talk a little bit about that as well later. Next slide. So also commanders are supposed to tell victims or survivors that they may be able to seek a civil protection order, but again, they are to respect the victim's choice. It's not a requirement that they do seek a civil protection order. And also commanders are, and this one can be really important, commanders are to make alleged abusers available for service of civil protection orders, since it's difficult for civilian law enforcement to serve service members who are stationed on installations. It can be really helpful to have memorandums of understanding with local law enforcement and military law enforcement, and have policies in place so that if local law enforcement needs to serve a civil protection order, that the military is making that person available for service, whether that be meeting them at the gate in order for the law enforcement to serve them, escorting, just different ways that they can make sure that that CPO gets served, so that the alleged abuser isn't using the military in order to try to evade service. And requests for orders, they can also request or order the service member to secure personal weapons until the commander, in consultation with the Family Advocacy Program, determines that there's a future risk. And again, we'll talk about firearms in a second, but just wanted to highlight that as far as in this context. So we can move forward. So we've talked about what commanders' roles are in military protection orders, but who qualifies for a MPO? Victims may qualify whether they are service members or not. If the perpetrator of the abuse is a service member and a current or former spouse, current or former intimate partner, or the parties share a child in common. Also, victims who qualify can seek both, as I mentioned before, and they can give time to seek that order, so they can be additional support. Next slide. So military protection orders can oftentimes contain similar relief to a civil protection order. Again, civil protection orders vary from state to state, but in general, orders, they can order the service, military protection orders can order service members to not contact the victim or the victim's family, stay away from the victim's residence or workplace, temporarily move out of a military residence shared by the parties, or order them into barracks, order them to attend counseling, and order them to surrender firearms or prove that they have surrendered personal firearms. The military forms also have a catch-all provision similar to civilian civil protection orders that provide the authority to order other provisions deemed necessary for the victim or their family's safety. And so sometimes we'll see where pets may be included here, if there's any specific unique to the situation kind of orders that might be in place, just like with CPOs, to really add in that protection that's specific to the needs of the victim. Next slide.
Stephanie, can I say something there? When you're talking about the military protective orders, one thing that people may need to know, because especially judges, because we think, oh, the service member was removed from the household and put into barracks, so therefore they must be the perpetrator of the violence. Under the MPOs, if the service member is the victim, because of the way the military works with service members and non-service members, the military, when they do that 72-hour cooling off period with the military protective order, can actually move the service member who is the victim out of the household and put them in the barracks, because non-service members can't be in the barracks. So just because a service member is one going to the barracks, don't think that that is just an automatic indication that the military thinks that they're the perpetrator. They may just be separating them to give them the cooling off period.
That's a great point. Thank you, Judge. Yes, so military protection orders are, the authority to them is about the service member being a service member. And so it's hard to order a non-service member out of housing. If both parties are in the military instructions do say that the victim should not be the one that has to bear the moving out of the house, and that it should be the person alleged abuser that moves out. So if they have the authority, they are supposed to at least order the alleged abuser to remove from the house. But if they don't have that authority, as in the case that Judge Fleming mentioned, then yes, it would likely be the victim. And so that should not be something that should be a consideration as to the validity of the allegations. So thank you very much. So this is just a picture of what the military protective order looks like. So we'll just want to, just to give you an idea that there are written forms, fillable forms, much like we have in civil jurisdictions. So there's that, and those forms, that form is DD form 2873. It's mentioned earlier in the PowerPoint, and it's also mentioned in the guide. And it has a lot of different questions as well about whether there is a civil protection order in place and such. So that's also important to note. It's a good document to kind of give a once over if you're in doing a lot of these types of proceedings where there may be a military protection order in place and you're looking at a civil protection order. So next slide. So really quick to talk about enforcement. MPOs are issued by the subjected service member's commanding officer, and therefore they're not in service enforceable by civilian law enforcement officers or courts. Generally, pursuant to the Violence Against Women Act's full faith and credit provisions, civil protection orders are enforceable across the United States, including on military installations and tribal lands, if the civil protection order was valid when it was violated, was issued by a jurisdiction of the United States with personal and subject matter jurisdiction, and the person subject to the order was given notice and an opportunity to be heard. So we really want to protect due process rights of those in civilian court. However, because this is only issued by a commanding officer, it does not meet that high burden under the Violence Against Women Act for military protection orders to be enforced off base. Pursuant to the Armed Forces Domestic Security Act, a CPO that does qualify under VAWA's full faith and credit provisions will have the same force and effect on a military installation as such orders within a jurisdiction of the court that issued the order. So there's also the this act specifically about armed forces that says that yes, they will give full faith and credit to those orders that qualify under VAWA. Next slide. So when we talk about civil protection order enforcement, all persons who are subject to a civil protection order, according to DoD instruction 6400.06, must comply with its provisions and requirements when present on a military installation. That means whether you're a service member or you're a civilian employee, you must abide by those CPO provisions. Service members failing to comply may be subject to administrative or disciplinary actions, and civilians failing to comply, including DoD civilian employees, may be barred from the installation, or if there are employees, they may be subject to appropriate administrative and disciplinary actions. So that's a bit of their enforcement ability. Next slide. So then what about that notification to law enforcement, civilian law enforcement? The military has policies that we are to make sure that these are entered into the NCIC, or the National Criminal Information Center. We enter most, that's the database that we enter most civil protection orders into for federal enforcement. It does not need to be in there to be enforced, but that's important to note. And while you might ask, why are MPOs in there if civil law enforcement can't enforce those orders? Because it alerts them to the existence of the order, and it should provide them contact information, because local law enforcement can inform the military about the potential violation, and the military can then handle violations of an MPO. They also put appropriate information into the National and Instant Criminal Background Check System. So moving on, trying to get through this a little bit quickly. So military protection orders can be modified or canceled. There are forms to do that that you can see here. Form 2873/1 or -1, and they last until they're canceled by a commander, as long as the subject service member is still under that command. If they are transferred, the military the current command should be telling the future command about the existence of the order. Next slide. And then finally, we're going to talk about the Lautenberg Amendment real quick and firearms. Specifically, the Lautenberg Amendment to the Gun Control Act prohibits certain individuals with a qualifying conviction of a misdemeanor domestic violence crime from possessing or transferring firearms and ammunition. DoD policy also says that qualifying convictions under tried by general or special court marshals do in their mind meet the definition of a qualifying crime under the amendment. So next slide. So we're really talking about, in that sense, we're talking about convictions of misdemeanors. Felony convictions are already covered under the Gun Control Act, as far as felons are prohibited from possessing firearms. So that's why that's why this amendment went specifically for misdemeanors. And military departments have procedures for asking for proof of surrender of personal firearms, and for making sure that government issue firearms or ammunition are turned over as well. And they're gonna do this in council with their staff judge advocate or other command legal counsel. And that's important to note, because there's also the official use exemption of the Gun Control Act, which applies to, if we can move to the next slide, that applies to provisions of the Gun Control Act, except for, let's say, for instance, except for that 922 D9 and G9 are the misdemeanor domestic violence convictions. So the official use exemption may apply to those that are subject to a civil protection order, in allowing them to still have possession of a firearm if it is in their official duty for the United States or any state department or agency. However, those practices, like civilian law enforcement, different military installations may have different policies related to that official use, and they may determine that somebody subject to a civil protection order should still not be in possession of firearms, even if it's related to their specific use. Another thing to mention just specifically about civil protection orders before I hand this over to Judge Fleming is that there are some cases out there. The Fifth Circuit did have a case about civil protection orders and prohibitions on carrying firearms. They found that it was unconstitutional, a violation of the Second Amendment. That's only the Sixth Circuit or Fifth Circuit. There is Sixth Circuit case pending out of Kentucky, also looking at that issue. So there are some issues related to that around the country. A lot of discussions about that. And if you'd like further information, please reach out and we can provide more information on those to you. And with that, sorry for taking some time, but I'll pass it over to Judge Fleming.
Welcome today. I'm Jason Fleming. I'm family court judge out of Christian County, which is where Fort Campbell is, which makes it really unique because half of my county is, or half of Fort Campbell's in Kentucky and half of Fort Campbell's in Tennessee. So we get all sorts of jurisdictional issues. And some of the most significant jurisdictional issues come in child abuse and neglect issue cases. So I'm going to talk a little bit about that. And then I'm going to do a little color commentary for Colonel Sullivan. You know, one thing that I will say to judges, if you do anything in military family law, it is well worth having Colonel Sullivan's military divorce handbook in your library. I'm not getting any payment or endorsement fee for this from Colonel Sullivan. I'm just being honest. It's a 2-volume book. This is the 3rd edition. I've had edition 1, 2, and now 3, and they are just fabulous to have as a resource. So if you don't have it, you can get it from the ABA. But when we're talking about child abuse and neglect issues, next slide. Military poses really complicated cases because in the majority of military cases, the family is not in the same area that their relatives and their support system is. So they have to look at different ways of handling the stressors that come with not only being young parents, because most of them are young parents, but they also have to deal with the stressors of being in the military, which includes deployment and training, having limited finances. You'd be shocked about what military families actually make. A very large majority of your young families that are in their first 3 or 4 years in the military actually qualify for food stamps. So they tend to be low income and they have a lot of frequent moves. So the family advocacy program on base is an important portion of what they need to be able to help them. Now, you've heard us talk about FAP in the domestic violence situation. It's amazing what one source and what FAP has available to service members. They are kind of the catch-all when it comes to social service on base. They also, unlike a lot of civilian social service programs, they deal with both the service member and the non-service member family member, and they deal with victims and batterers if you're talking about domestic violence. So that is usually the first stop because FAP will be able to provide information to the military family if they don't provide a service on where they can get help for that service. One thing that we also have to remember that we use lots of acronyms in the military. A PCS is a permanent change of station that occurs every 3 or 4 years. For most families, an ETS is the end of time of service, which means that they're getting out of the military. So if you hear the word PCS, that just means they're moving to a different base or duty station. If you hear ETS, that means they're getting out. Next slide. So the big thing that happens with military families, unlike our families that we have in our normal dependency, neglect, and abuse courts, where chances are they have other family members around that we can look at placement, military families generally do not. So you have to look at 2 different things. One is if you are in a state that's fortunate enough to have fictive kin statutes, which Kentucky is one, but not every state has a fictive kin statute, then placing with another service member or their family is a possibility, because the fictive kin statutes say that instead of just placing children with a blood relative, that we can place children with a person that is like a blood relative, that is like an aunt, an uncle, a grandparent to the child. And many service members, when they go from duty station to duty station, develop those close-knit friendships that would qualify as fictive kin placements. The other alternative to foster care is also doing a ICPC to another state to be able to place the children with a family member. That's the Interstate Compact for Placement of Children. All 50 states plus the District of Columbia have the ICPC 1. There is an ICPC 2 that has been approved by 14 states, but it does not go into effect until 35 states have ratified it. If you want to really help children in your community and your state has not adopted the ICPC 2, that would be one area to look at, because the ICPC 2 is not just better than the ICPC 1, it is significantly better than the ICPC 1. It has all sorts of different mechanisms to make sure that children are safe and placed in family homes without having to go through all the processes that the ICPC does. But for anyone who isn't familiar with the ICPC, it is a very long process. The minimum is if you qualify for a Reg 7, which is for children under 2, or for placements where the child has been previously in the home, you're looking at 20 business days, which would be 30 days of real time. And that is, if everything goes well, generally it's still a 60-day process. If it does not qualify for that Reg 7 special status, then you're looking at sometimes 6 months to a year to be able to place the children with a family member to give them the support they need. So the ICPC 2, especially for military families, has an exception for military families, and it will be a large benefit for them. The other thing that you may need to know for your state is if you've got a biological parent in another state, is whether or not your state believes that on a non-offending parent that the ICPC applies. About half the states that have addressed the issue of whether or not the ICPC applies to a non-offending parent says that it does not. About half the states that have addressed it says that it does. If your state does not says that it does not apply, then you can place the child with a non-offending parent in another state without violating the ICPC. But I will now turn it over to Colonel Sullivan so that I can now play pinch hitter to him. Colonel Sullivan.
Thank you very much. Fabiola, are you able to transfer the control over to me so that I can advance the slides? If so, I'm going to try with a test to see whether I can move from this slide to the next one.
Go ahead and try, Colonel Sullivan.
Come again?
Go ahead and request access.
Okay.
Up at the top, Colonel Sullivan, where it says you are viewing Fabiola Rincon's screen, see view options, hit that view options, and then go down to request remote control.
Got it. All right. And now I should be able to advance the slides. Let's see. Okay, there we go. All right. Thank you for your patience. Sherry has given me what is called in baseball terms the cleanup slot. And so I've got 15 minutes to do 30 slides. And obviously, I'm not going to do the same kind of excellent job that Stephanie and Jason have done, but I will try to flag the issues for you so that you don't feel like you're feeding from the fire hose in listening to this. 99% of my work in private practice involves military issues and cases, including military pension division, I have been an expert witness in at least 12 different states, helping judges to try to understand these areas. I'll try to flag for you what is available in the resource guide. What we're going to talk about, first of all, is juvenile justice cases. And we talk mainly in the resource guide about the exclusive jurisdiction and current jurisdiction issues. There are places, Fort Liberty, formerly Fort Bragg, as an example, where portions of the installation are exclusively federal jurisdiction. Theoretically, they don't even exist in the state of North Carolina at all. And there are also areas of concurrent jurisdiction where the state and the federal government have control. But these are issues that are important. They are mentioned in the resource guide. In addition to that, we will also talk about these issues in the resource guide. Primary, which Jason has mentioned, is the mobility of the military family. That PCS that Jason mentioned, the permanent change of station, can occur every 3 to 4 years. So you have people that are going from North Carolina to the state of Washington, to Germany, then to Georgia, then to Japan, every 3 or 4 years. We have put questions for the judge to ask in our materials as well as resources. We also cover issues such as truancy and school attendance and questions to ask in the resource guide. And probation and monitoring also in the resource guide. The domestic relations case is another area where the judge can get involved with military families. This is the big enchilada. This is the area where the judge might need to know about divorce and custody and support and alimony or spousal support or property division. One of the chat notes said a military member's service can be used against them. And that's probably true. We have questions at the end of this. Perhaps we can get into that. Certainly there are areas where it shouldn't be used against a service member. I have obtained military custody, for example, for military personnel against their civilian spouses in a number of cases. But I also have cases where, to be quite honest, Judge Fleming, I think that the service member's service should be used against him or her. Now, that can sound awful to some of our attendees, except when I tell you that if Sergeant John Doe, our hypothetical dad, is Special Forces, moving around with little notice, and has a child who needs stability and special services and special care day in and day out, you in your courtroom, or I as an applicant in your courtroom, would probably stipulate that that child needs the stability of a non-military parent instead of the mobility of Sergeant John Doe in Special Forces. So we will talk about that, and I'll be happy to entertain questions in that area. When we go forward in the Judicial Resource Guide, you'll find that the SCRA is involved as well, the Service Members Civil Relief Act. Here's where you can find it. Here's to whom it applies. You will see that there are protections available for service members against default judgments, and there are also provisions for a stay of proceedings. The place where you will find this information is the publication shown at the top here, A Judge's Guide to the SCRA. Now, Jason, they're probably saying, Mark and Jason, where am I going to find this thing? Where is the source of this? And the answer is shown here, www.nclamp.gov. That's the Military Committee of the North Carolina State Bar. I have posted over 100 info letters there. These are two of them. The second one is the guide for the appointed attorney. Are we there yet? So you can find those resources, ladies and gentlemen, at that location, as well as questions that the court might ask. There was a question in the chat, Jason, about what can we do when the court tramples upon the rights of the service member? What can we do? The answer, ladies and gentlemen, is found in two cases from 2015. The first is a North Carolina Supreme Court decision reprimanding Judge Brenda Branch, a trial judge in North Carolina. If you look up in re matter of Brenda Branch, B-R-A-N-C-H, January 2015, a public reprimand or a judge who did not know or did not apply the Service Member Civil Relief Act. The second is an issue, Jason, directly from your court, or I'm sorry, from your state. A 2015 case, which is called Wood versus Wiest, W-O-E-S-T-E, Wood versus Wiest, Kentucky App 2015, in which the judge refused to allow a stay of proceedings, and there was a writ of prohibition requested and applied for and obtained from the Court of Appeals when that motion for a stay was denied. So there are remedies that are available to the parties in this area. The other issues that we should talk about involve limitations on the SCRA and custody orders that can be entered during an individual's deployment. The Uniform Deployed Parents Custody and Visitation Act, shown here. The issues of how difficult it is for a trial judge to determine the home state of the minor child and whether the court may need to use the secondary test shown here under the UCCJEA, the Uniform Child Custody Jurisdiction and Enforcement Act. Also, there are questions to ask by the court, and trying to get it to advance, and there we go. Okay, and the area of custody and family support and resources for the court will be found in the resource guide. We also have questions for the judge. In particular, look on this slide to see about the military support guidelines that are available. That is the Army or Air Force or Navy's requirements in the absence of a court order or an agreement, and how to enforce through the military a civilian court order. Now, in this area, Judge Fleming, somebody might say, how do I get that QDRO entered? What about jurisdiction? Now, those are issues that, in addition to what is shown on this slide here, we're going to find in the next slide outlining what's in the resource guide. That's the statute, the Uniformed Services Former Spouses Protection Act. That is the location of it. And when somebody comes to Judge Fleming and says, who's supposed to write this QDRO? My friend Judge Fleming ordinarily would say what?
My suggestion is that the spouse receiving should be the one that drafts it to make sure that they are getting what they are entitled to get under the law. So I think that is always the best method under the Uniformed Services Former Spouses Protection Act. Colonel Sullivan, let me say one thing about the SCRA. There is an excellent flow chart that you have created for the SCRA on whether it applies or whether it doesn't, and whether it should be renewed after 90 days and whether it shouldn't. And that NC LAMP website is also excellent. It's divided into 3 categories: one for lawyers and judges, one for attorneys, and one for military service members and their spouses. So it has information regarding whatever way you come to a family court. It has something that addresses whatever your concerns are.
Thank you. You will also know from the resource guide that there are 3 possible jurisdictional tests. You must make a finding on what the basis of jurisdiction is in your order to divide the military pension. And we talk about how to determine a service member's domicile or state of legal residence. The materials will also talk about the 2 retired pay centers shown here on this slide, and also the 4 types of orders that are acceptable. Ladies and gentlemen, this is not a time when you want to try to create your own version because you think you're very creative. This is a time to slavishly copy what is out there and what will be acceptable, or at least to recommend that to the attorney who is designated to write the military pension division order, rather than trying to start from scratch and do it yourself. This is also an area where you'll find that there are limits on what the court can order for garnishment from the retired pay center. There must be 10 years of marriage overlapping 10 years of military service.
And can I say something about that, Colonel Sullivan? Judges and attorneys will hear the service members say, well, we weren't married for 10 years, so that means that they cannot get military retirement, except for a few states and Puerto Rico, which have vesting issues. That is not true. They cannot get it paid directly by DFAS, the Defense Financing and Accounting Service, directly to the former spouse. They have to pay it directly through something such as a constructive trust, but they are still entitled to their share of the military retirement. In fact, Kentucky has a case that says that even if you're married only 6 months, that you're still entitled to that 6-month share of the military retirement.
Thank you, Judge Fleming. The next slide shows the documents that Judge Fleming would expect to see in cases involving active duty. That's the LES, those in the Guard Reserve, or one who is retired. These are the documents that are important for the judge to look at. Also, there's a section on domestic abuse shown here and how you can divide a pension. Listen to this closely, how you can divide a pension that does not exist. Finally, we'll talk about the area of the frozen benefit rule, which requires a snapshot on the date of divorce of what can be divided in most cases. The VA waiver is the second bullet here, and that is how the pension is reduced by the amount of VA money that Sergeant John Doe gets. CRDP, or the restoration of that amount which is waived. CRSC, combat-related special compensation, which talks about another form of disability payments. And finally, the issue decided in 2017 in an opinion by Justice Breyer in the U.S. Supreme Court, limiting the power of Judge Fleming to order in a contested case any indemnification for Jane Doe, the spouse of Sergeant John Doe, when there's the potential of a reduction in the amount she's getting due to the VA waiver.
But Colonel Sullivan, I do have some ways of remedying that. One way is if the parties agree to it, I can still enforce it. So if the parties in their agreement say that there will be an indemnification, then I can enforce that indemnification. The second thing, which is what the Howe case says, is that I always reserve the right to either look at whether maintenance under the state maintenance law or alimony law, depending on what state you're in, should be revisited, or whether or not the property settlement should be reopened and litigated.
That's right. You will also find reference in the guide to a medical discharge, military disability retired pay, as shown on this slide. Some people forget about the death benefit when they're dividing the pension. The pension is only good to divide the pension of John Doe while he's living. But when Sergeant John Doe predeceases Jane Doe, then we have to talk about the survivor benefit plan, which is also covered in the guide. This is where you will find the SBP. It's an important issue to raise with the parties in the pretrial conference. Is SBP going to be an issue? Has it been waived? Those are things that the court will need to find out. What is the cost for the SBP? As my friend Judge Fleming says, who's going to pay that cost? Who's going to pay for this puppy? That's an issue that is addressed also in the resource guide. And how to lock in the SBP with the 3R rule covered in the guide. There's also a defined contribution plan. I have a handout, a silent partner handout called TSP, the Thrift Savings Plan, and that will cover all of the issues that are listed here. Those resources are in the guide. This is what it's called. The order that you enter is an RBCO, not a QDRO. It's privately administered. You can find out information by going to the search engine with that phrase that I've shown on this slide. And there is now a fee. As of 1 year ago, the fee of $600 came in, and it's debited once upon the submission of any order, draft or signed. The spouse can obtain either a fixed sum or a percentage, depending on your order. And depending on Jane Doe's decision, because it really is the spouse's decision, whether there are passive gains and losses or whether it's a fixed sum as of the transfer date that you designate. The final issue is vacation time or accrued leave. Some states like Illinois and Maryland do not allow that to be divided. It is too speculative. There are other states like Colorado and Florida which say it's divisible, and there's case law on that. So those are issues as well in this area. And now I'll turn it back to Sherry.
Thank you, Judge Fleming. So before we get to some time for questions, we want to talk a little bit about what the guide says you can do. And so anyone in any jurisdiction, whether you're near a military installation or not, you can start by asking families that are in your courts and in your dockets if they're military connected, whether it be for child abuse and neglect, if it's a juvenile there, if something comes up that you have reason to believe maybe they're connected to the military in some way, start by asking that question, noting it in their file, because it could mean differences in ability to share resources, but also about some of those ICPC and ICJ, if they're going to move quickly or not be available for hearings, you'll want to know that in advance. Another easy thing that anyone can do is just make sure that you provide some training to your judges, attorneys, social workers, probation officers, your victim advocates, anybody, court personnel, court administration, but also offer it to your treatment and community providers about the unique needs of military families. A lot of that information is found at the beginning of the guide. We can help provide that training or give you the content to provide that training to your bench and to your court system. Those that are near a military installation, you can outreach to your nearby base command or start with the family advocacy program and do some introductions and just to build relationships and get to know each other and who are the contacts at the court and who are the contact people at the military installation. And then the next higher level thing you can do is convene a meeting with representatives from the military installation. Make sure you invite command, make sure you invite family advocacy program. You might ask them who else they think might want to be involved in the meeting and some of the things you can talk about or about some of the resources that you have and the military system has for families. What are some of the gaps in resources? It should be a very lively conversation from our experience. And then talk about some of the challenges for military families that are in the court system and how together you might be able to address those. Next slide, please. So the National Council, under our funding created several years ago, the National Resource Center on Military Connected Families in the Courts. That is a link to it on the NCJ-FCJ website. And it is a resource center. It has tabs and key sections around any sort of legislation that might be pertinent to military family cases. A lot of information about veterans treatment courts, some examples and a template for developing memorandum of understanding. We have links to a lot of allied organizations working with military families that also offer training and educational opportunities. And then a lot of information about the work that we have done at the National Summit. We've convened 2 national summits. We have done quite a few webinars on various topics. And so we invite you to take a look at the Resource Center. But the other reason that that link is important, and I'm putting it in the chat, is tomorrow that will be the site of where the resource guide, once it's published, will debut and will become part of the Resource Center. And then some days later, a recording of this webinar will also be posted to the same Resource Center. So lastly, I believe the last slide is just to say thank you and open it up for any questions. I've come through the chat and I believe most of the questions are around a few things for our faculty. You've addressed some of them throughout the webinar, but we have questions around Caden's Law, which is a law that addresses parental alienation and what its impact is to the military. How do we ensure that courts adhere to the Service Members Civil Relief Act? and questions around false allegations against a service member. Family court seems to be a ripe opportunity for false allegations. And how do the courts, or how does the family advocacy program address parental alienation and or false allegations? Does anyone want to speak or touch on those issues?
I'll start it, and then Colonel Sullivan or Stephanie can join in. As far as Cadence law goes, of course, it has not passed in very many jurisdictions, if any yet. I know Pennsylvania is probably where it's most likely to pass if it hasn't already. But Cadence law was in the VAWA reauthorization to allow incentives for states to pass parental statutes that would, for people who it would pass statutes that could lead to more parental alienation. It basically, Cadence law basically says that if you have a situation where there has been family violence against anybody, then that person that perpetrated the family violence has a presumption that they should only have supervised visitation. So that's the basis of Cadence law. There's other things in it as far as training for judges, the elimination of certain experts being able to testify. So there's a lot of restrictions on it. So far, it hasn't gotten a lot of traction in the legislators, but now that there's money tied to it, you may see that come along. And I think that would have a significant impact on military families, especially because if the courts do apply it and go with the presumption that says that supervised visitation is needed, who's going to supervise those cases, those visitations? Because, like I said earlier, military families do not have a lot of family members in their area. In most cases, their family members are in other states. So who's going to supervise that? I think Colonel Sullivan has already talked about the SCRA and the violations of it. What was the third question, Sherry?
Was really about family advocacy program and false allegations and how anyone would be addressing those.
I'm not sure that how FAP actually addresses false allegations. I know that false allegations come into FAP just like they do with court, or at least allegations that can't be substantiated. They may not be false, but can't be substantiated. I know if the military service member makes a false allegation, of course, they're subject to the UCMJ, and they can't make those. But a non-service member, family member, is not subject to the UCMJ, but they are still subject to state law that would be applied on federal installations. So, for example, falsely reporting an incident is a Kentucky law that would cover that situation, and they could bring a violation of that state statute in federal court if it happened on base. The one thing that we do need to remember that if the service member is the victim of domestic violence, that is an exception to Army Regulation 608-99, which is the family support regulation, that the chain of command can cut back the amount of family support that the perpetrating non-military spouse would receive from the service member during their time of separation. Colonel Sullivan, Stephanie, anything else?
I'd just say that with the family advocacy program, it would also depend on how they were reporting. If they were reporting unrestricted, then there's going to be an investigation. So that would be what the protection would be against allegations of false allegations, that there would be an investigation by law enforcement. As far as the restricted reporting, all that really that just gets them victim advocacy services. So that's not going any farther than the victim advocacy program in general. So that's something to keep in mind with the protections as far as against false allegations.
As a trial lawyer, I can say that there is sometimes no redress for Sergeant John Doe, the service member, regarding those false allegations. However, in our firm, we have had several cases in which those false allegations have come up, and we have not hesitated to use them in court to show the judge that Jane Doe, the spouse, has leveled false allegations against John. The question is, how much weight will that have to the judge? Will it sway the judge in one direction or another, either to limit or impair the credibility of Jane Doe, or to have some certain result in the area of spousal support, child custody and visitation, or other things? Much of this will depend on the nature of the case and the nature and seriousness of the false allegations.
Mr. Joyce, wasn't Hayden's Law recently incorporated in the Reauthorized Violence Against Women's Act? It was, that's what I mentioned with VAWA, but my understanding is it is a funding mechanism that states can be eligible for funding if they adopt certain portions of it. And the more they adopt, the more funding that they can receive. I think 25 million is what they have allotted, because a lot of times the federal government can't mandate states to do things, but they can sure incentivize them to pass certain laws.
Well, I think that's all the time that we have for the webinar today. If you're paying attention to the chat, Fabiola has put her email address if you need a certificate of attendance, and then also a link to a survey to just briefly, it's short, to tell us how we did on the webinar today and any feedback or future topics you would like to see. But I would like to give a round of thanks to our faculty, Judge Fleming, Colonel Sullivan, and Stephanie. They did a wonderful job. And so if we can just acknowledge them and the job that they did, I would appreciate that. And then thank you to everyone who joined today. We appreciate your time, your interest in the topic, and your questions. And feel free to continue to email questions to us. I put my email in the chat. But we will be emailing you as soon as the guide is debuted and is public, a link to the guide, as well as a copy of the PowerPoint slides, which were requested and always popular. So thank you, everyone, and I hope the rest of your day goes well.
Thank you.